and they've asked me to come and spend a little bit of time with you today. We're going to look at the American Constitution, and we're going to look at the Michigan Constitution, and then we're going to look at that in the context of, what are these constitutional liberties that we inherently know are on our heart, and we know that there's something wrong going on here in our government, and let's understand that. And that's what we're going to do in the next little bit as we're talking here. So, let's go back, right into, the time of our founding, and we hold these truths to be self-evident, that all are created equal, endowed by their Creator with certain inalienable rights. Now, our founders understood that the nature of man is that we weren't born good. We certainly, if given to our instincts, that Lord Acton was correct, that power tends to corrupt, and absolute power corrupts absolutely. So, the framers of our Constitution understood that. And I've got the Constitution here, and we're going to be looking at that a lot today. They put together a framework for our nation that understood that very nature of man, that power tends to corrupt, and absolute power corrupts absolutely. And if you are thinking about some of the executive actions and the absolute power and the way that absolute power has been used to respond to our pandemic, you're not too far away. And unfortunately, the response seems to prove the case that power corrupts absolutely, as opposed to prove an exception to it. But because our founders understood that truth, when they set our country up, they didn't put all the power in one place, and there was a reason that they did that. If you put it all in one place, people are going to do what people do. Think of a baby. If you have a baby, and let's pretend this is a rattle, and you give the baby a rattle, and the baby plays with the rattle, and then, a second baby enters the picture. Does the first baby crawl over and say, "Oh, here, we're all born good. Let me share this rattle with you, and we will play together nicely and we'll all get along"? No, that doesn't happen. In fact, and I've used that illustration all around the world, and it doesn't matter what the culture is. Every mother in the audience will tell you exactly what the baby says if you introduce the second baby, and because the second baby says, "Oh, I want the rattle," and the first baby says, "No, it's mine." Well, those babies grow up, and a lot of them work in government, and I tell you that rattle is very much like power, and people aren't. When you give somebody power, and you give somebody absolute control over one kind of power, they're not going to want to give it up, and they say, "It's mine." Well, that's kind of what our founders understood. And so they didn't put all the rattles in one place. They didn't put all the power in one place. They divided power first between the federal government and the state governments, but then even within the federal government, they separated power between the executive branch and the legislative branch and the judiciary branch. We hold these truths to be self-evident, that all are created equal, endowed by their Creator with certain inalienable rights, and those rights and those liberties serve as limitations on the exercise of government power. I'm holding a power cord here, and we're going to use this power cord to represent the exercise of government power. Whenever you see somebody in government acting, I don't care if they are in the federal government or if they're in the state government, if they are in the legislature or they're in an executive branch, if you see a person with authority using power, you have to ask about the other end of the cord. What is the source of that power? Because if they're exercising power, they're only exercising power properly if they have plugged into a proper power source. Now, in our country, the power source is the American Constitution. And in our state, the power source is the state constitution of the state of Michigan. So you have to ask, for example, if the governor has an executive order, what in the Michigan Constitution authorized the exercise of that power to issue the order? Where did she plug into the Michigan Constitution? Or where, if the Michigan Constitution has authorized the statute, has she plugged into a statute authorizing the exercise of her power? Now let's look at the federal government, because our founders really kind of understood the importance of separating power. And they said, so if you see anybody in any branch of government acting, so if anybody in this building is acting, for example, if they're using their power, and I suppose I should have some red tape on the end of this cord, just because when government uses its power, it tends to create a lot of red tape. But when you see Congress using its power, the question is, did they plug into a proper power source? And if Congress doesn't plug into a proper power source, then the exercise of that power is illegitimate. If the governor doesn't plug into a proper power source, then the exercise of that power is illegitimate. Let me give you a simple illustration. There is a rather famous law that everybody has heard about it. It's called the Affordable Care Act. Many people on both sides of the aisle now call it Obamacare. But the Affordable Care Act, when that was passed by the Congress, everybody asked what was the proper power source, because that was a significant exercise of power regulating the medical profession and the practice of medicine. And so, well, all the lawyers, what they do, they went and got the power sources, and they looked in the power sources, and they started looking for a power source that would have authorized Congress to actually enact that law, giving Congress the authority to do that. And they said, well, it's practice of medicine, and I don't find the practice of medicine anywhere in here. In fact, I think the states are the ones that kind of regulate all the medicine. But so, well, let's just keep looking. And so they put it under some brighter light, and they found, they said, well, this is kind of like commerce. And here's a power source that says we can plug into the Commerce Clause, because it says that commerce can regulate commerce among the states. And so that's what they did, and then the Affordable Care Act became law. Well, that was immediately challenged, and they took the exercise of power that created the Affordable Care Act, and they challenged it in the courts. And then when it went to the courts, and it went to the U.S. Supreme Court, the U.S. Supreme Court looked in the Constitution, the places where they said they found their power source, and they could not. They said, no, this is the practice of medicine. This is not commerce. This is not in here. So therefore, the Affordable Care Act is a violation of the Commerce Clause. It's not constitutional. Now, you didn't read too much about that because it was on the back pages of the New York Times in very fine print. But the other reason you didn't read about it is because the administration at the time had very good lawyers, and they went to the Supreme Court and they said, well, we've always got good lawyers always have a backup argument, of course. And they said, we've got an alternative argument. Right here in the Constitution is another power source that Congress could use. It's called the tax and spending power. And because the Affordable Care Act, because Obamacare, really is a tax, and we're not going to say that too loudly because it's a pretty big tax, and the IRS is the one that enforces it, and it kind of like if it quacks like a duck and swims like a duck, and if it looks like a tax and acts like a tax, it's a tax. And so the Supreme Court said, well, right, the exercise of government power by Congress therefore is proper, and they upheld the idea of the Affordable Care Act because why? The exercise of power now had a proper power source. Keep that in mind when we come back to talking about what's happening here in Michigan, because we're going to ask the governor, do you have a proper power source that you've plugged into that are authorizing your executive absolute power orders here? Now, the next thing you have to ask somebody in the government that's exercising power is, even if you have plugged into a proper power source, even if you've plugged into a proper power source, what the government cannot do is then use that power in such a way that interferes with any of your unalienable fundamental liberty. Let me say that again. The first thing you ask is, did government plug into a proper power source? Even if government is plugged into a proper power source and they're acting within the scope of that power source, they cannot use that power to interfere with any of your unalienable rights. And let me just go through a couple of them. You have the inalienable fundamental right of free speech. You have the inalienable fundamental right to petition the government for redress of grievances. You have the inalienable fundamental right to the free exercise of your religious conscience. You have the right to due process before the government takes away your liberty. You have a fundamental right to worship in your church or your synagogue or your mosque. You have a right for the government not to impair any private contract. You have a right for the government not to take your property without due compensation. And I can go on and on and on. And as I was going through that list of liberties and those list of rights that place a limitation on the exercise of government power, how many of you were thinking, well, wait a minute, doesn't this order interfere with my right to the free exercise of religious conscience? Now, wait a minute, doesn't these orders interfere with my right to petition the government for redress of grievances? My goodness, they gave this extension to allow the governor to exercise this absolute power, but they didn't let me in the door when they did it. The governor has literally shut down many places. But was I able to have free speech? So as you're thinking, as we're going through these things, I'm going to come back to them. But we're looking at the big picture now, and we're going to have a test afterwards. No, just kidding. But remember, first thing, did they the government plug into a proper power source? Because if they didn't, then their action is without authorization. Even if they plugged into a proper power source, did the action in some way interfere with your constitutionally protected liberty? Because if it did, then it's also invalid. That's the big picture. That's the big picture. The way that our founders set up our wonderful country and set up this Constitution is, yes, they divided power among the branches of government. But then they said, whatever specific powers in here, like the commerce power we talked about, or, for example, the reason you get your mail every day is because there's the postal power in here, and government plugs into the postal power, and it's authorized now to take your money and deliver your mail. In addition to the enumerated powers that are specifically given to the federal government, all the rest of the power that's not listed specifically in here, all the other power sources that are not put into the Constitution, all those rest of those those plugs go to the states. All the rest of the power goes to the states. Under the 10th Amendment, it says if the power is not listed in here, in the 9th and 10th Amendment, it says the rest of the power belongs to the people and to the states. All right. So that's where you see the state exercising power now, because the police power is not listed in the Constitution. There is no police power in the Constitution. And yes, certainly we see FBI and DEA agents, and they say, well, then how do they prosecute federal drug crimes? Well, not because they're using the police power. They're doing it because the distribution of illegal drugs is commerce, and under the commerce power of the Constitution, Congress has the power to regulate commerce, and that's why the DEA and the FBI can prosecute drug cases. But the general police power is reserved to the states, and that's why you see these governors across the country and state legislatures across the country using their police power to address the pandemic that we are dealing with. Now, the question we have to ask is, a pandemic that, to be sure, does kill people, is the response to this pandemic something that's going to kill all our fundamental liberty for much longer to come? And these are serious questions, and your organization that and your Facebook group that has come together here, you are living in an historically an important time, and your cause is very, very important. And the fact that you care about this, I just want to let you know, really, really matters. Because we haven't had a threat to our constitutional liberty like this in my lifetime. I taught constitutional law for 30 years. I sat on the federal bench, and I worked in the United States Department of Justice before that. And in all those 30-some years of either practicing constitutional law or teaching it, I have never seen a time in our nation when our freedom and our liberty is more at risk. Lord Acton was right. We are faced with a situation where power tends to corrupt, and absolute power corrupts absolutely. And let me tell you, the only thing more contagious than the virus is abuse of power. Perhaps emboldened by the executive branch's use of absolute power in the last number of weeks. Just recently, the judicial branch, a number of judges in the Michigan judiciary, have issued what are the technical term for them are called general warrants. General warrants is what the British used to, use. They don't name anybody, and it empowers a police officer to arrest anybody they want. It doesn't name a person, doesn't give you a right to a hearing, and we've got in Michigan now, for the first time, as far as I know, since the 1700s in the United States of America, we've got judicial authorities issuing, general warrants. Now, I have a number of lawyers that are, responding to that, and we hope to, help these judges, reread the Constitution that they're sworn to uphold and get that fixed in the next week or so. But that's what happens when absolute power becomes contagious like a virus does. Let me bring us now, and I know I feel like I'm a fire hose giving you a lot here all at one time. I will, point you to some places you can go when we're done here and get some good summaries of this. If you go to, our Salt and Light Global website, I will post a good outline of a lot of the things we're talking about here. And so hopefully you'll, even if you miss some of the stuff as you're writing it down, you'll be able to review it. Let's talk about the executive order, though. First question again: did the governor plug into a proper power source before exercising power? If you ask the governor, she'll say she did, and she'll cite 3 or 4 parts of the Constitution that talk about all executive authority being in the governor, and et cetera, et cetera. And then there are a couple of statutes. One of them is like a World War II era statute that was enacted by the state legislature. So yes, we the people, through our representatives, did enact a statute in World War II era. There's another one that was more later in the 60s that talk about emergency powers and give the governor certain exercises of power. Now, I have some, serious question about whether the governor is acting within these constitutional and statutory authorities in some of the orders that we have. For example, you see an order that is regulating the education of the state of Michigan. Michigan's constitution, is very different than the rest of the states, and we have almost a fourth branch of government called the State Board of Education. And the State Board of Education is its own constitutional entity, and it's charged with setting policy, for the state of Michigan with regard to education. That's the part of government that should be setting education policy here. To be sure, the governor probably has the power to close the buildings, the school buildings, but not to, be setting the policy. And so there are some other statutes that talk about Department of Health and Human Services being responsible for, policy in emergencies like the one we're in, and yet it's coming out of the governor's office directly. So there are some serious, questions that need to be looked into on whether even, whether the governor has plugged into a proper power source or whether she's acting within the scope of that power source that she's plugged into. But let's assume for a minute that the power source was proper. And again, I don't think that's necessarily something that should be, a given. But let's assume for the sake of discussion here that the power source that the governor plugged into, entering all these orders that say stay at home, prohibiting, any number of people from gathering any place for any purpose, subject to the few exceptions that are there. Let's look at those and let's ask the question, does that exercise of government power, even though we're going to assume that it was a proper power source, interfere with any of our constitutional liberties protected by the Michigan Constitution and the state constitution? Absolutely. We are, think about equal protection under the law. We're supposed to be treated under the law, the same. If you look at just at the medical restrictions, some hospitals in Michigan are really hurting right now because all their for lack of a better term, their patients aren't allowed to come in. There's no elective surgeries allowed in the state of Michigan. Well, except for one. If you want to have elective surgery with regard to abortion, that seems to be given some special kind of protection, and other kinds of elective surgeries, and some of these elective surgeries, are really serious surgeries. That if you need your hip replaced, you can't. If you need to have, some things done with your heart, with meeting with your cardiologist, you can't. And so, some real serious questions about the way that the executive actions are treating some groups differently than other groups. And here's the interesting thing. The state says that the reason that we are authorized or justified in interfering with your constitutional liberty is this health and safety concern that we have. Well, if that's the case, then why are the rules not connected to why don't they ask the question, what is safe and what is not safe? We're going to allow what is safe and we're not going to allow what is safe. Instead, they use this politically charged term of what is essential versus non-essential, and then through a political lens, they decide what gets to be essential and what doesn't. And so in Michigan now, we can smoke grass because that's considered essential, but don't hire your next door neighbor to mow it. That's not considered essential. Or don't hire the one person, sole proprietor that has a grass cutting business because he can't come in and cut your grass. These are significant questions that need that where we need, as we the people, need to in the proper way respond and exercise our rights to petition the government for redress of grievances. If you're a pastor of a church, every pastor on Resurrection Sunday or Easter Sunday last week was forced by these statutes, these executive orders rather, to commit a crime. And to, even if you were not meeting as a church, but you had 2 or 3 staff come and run some equipment so that you could live stream a sermon. That is a crime, and that is and it's prohibited by the order. One of the things the state has done is they make these things a crime, and then they do something either by answering a frequent, when there's pushback. You can go to a website where they have these frequently asked questions, and then they answer. They write a question up, and then they say, well, we're really not going to enforce that against churches. Well, if that's the case, then change the law, because right now you've made it a crime to do so. Or they put in, under the pretense of protecting religious liberty, for example, they put in a provision that says, a place of worship, when being used for for the purposes of worship, will not be subject to the penalty. Well, let me translate that for you. Under the law, that means you're still committing a crime. You still can, have a criminal record and have a fine, imposed on you. But perhaps the church body itself, the actual corporate entity of the church itself, after it's convicted, it won't have to, be subject to the penalty. That doesn't provide any kind of exemption or any kind of, relief to, a pastor who wants to have 2 or 3 of his staff gather with him in a very safe way with lots of social distancing and do a live stream message. We can go on and on and on. The businesses, the number of calls I've received from small businesses and how, they just don't, they ask the question, how could this make sense? And they're looking for, somebody to make sense. Well, you can't make sense of something that doesn't make sense. We have in this town of Lansing where I live this incredible little, it's not little anymore, it's a huge place where you can go buy groceries, but it also has a huge nursery, and it's a place where people go to grow their gardens. They buy the seeds, they buy their plants, and this is where you go, and this is the time of year you go to get it. Now all of a sudden, with just some ink and a pen, overnight, you're in the same place, and instead of, picking up your milk and grabbing a tomato plant that you plan to plant so that you can feed your family later in the summer, you're now committing a crime if you grab the plant. Makes no sense at all. But again, we have to put this in the context of the law, and how is it not only does it make no sense logically, but are they taking property without due compensation of this business that has bought all these plants, and they're ready to sell them, and now they can't sell them, and they're sitting there drying up on the vine? Is there an impairment of private contracts if a friend of mine who owns a lawn mowing business, he enters into these contracts for the summer, and now the people that he's got a contract with is expecting him to mow the lawns, and the state's coming in and say, if you mow their lawn, you are committing a crime, and we're gonna cite you. Is that government impairment of a private contract something that is actionable? Stopping a church from being able, to share their religious message, is that actionable in violation of the First Amendment? When people were not allowed to go into the state legislature to petition their government for redress of grievances, these are specified constitutional liberties, both in your state constitution and in your federal constitution. And when government exercises authority saying that you cannot do that, well, do we have causes of action? Well, I want to kind of close and finish up here by showing and discussing something that we need to understand in the rest of this mix, because Well, why don't we go sue? Well, part of the reason it might be a good reason to hold off is because the courts have, through very activist judges sometimes, taking these very clear constitutional provisions and rewrote them or interpreted them to say, well, government can interfere with your rights if they're justified. And I understand that, nothing is absolute. You can't say, you can't yell fire in a crowded theater, or you can't rob a bank and say, give me your money, and then say, hey, I've got a right of freedom of speech as my defense. I understand all that. But what government does, and what the courts have enabled them to do through some of their judicial activism by interpreting these cases, is they've said, well, sometimes we're not going to, treat that right as something that's really significant. So government doesn't have to justify it. They can just have a legitimate reason for what they're doing. And certainly, now the executive branch would say, hey, we've got a very legitimate reason. We're trying to stop the spread of a pandemic. If the right is considered more fundamental and some lawyer wearing a robe somewhere says, we think this is a more significant constitutional liberty, we're going to hold the government to a higher standard, and we're going to require that they have a compelling government reason if they're going to use their power in a way that's going to interfere with what we deem to be a fundamental liberty. And so what I'm afraid is going to happen is too many people are going to file lawsuits right now. And there are Supreme Court cases out there that from 1905 even that talks about a government having a compelling government reason in stopping a pandemic. Now, as each day proceeds forward, we've got the amount of the virus and the amount of cases going down, and you got that flattening curve that everybody's been talking about. Guess what? As that's happening, the government's justification for interfering with your rights is less and less. And so the chance of winning a case every day is greater. And I tell you right now, we'll be filing a number of lawsuits on behalf of some parties on May 1st if the executive branch decides to extend this use of absolute power over our lives. In the meantime, you don't have just the court as your remedy. You also have your voice, and you have what you're doing here with your incredible Facebook group. I mean, there are so many incredible things that you can do. Ultimately, it probably wouldn't be a bad idea to remove that power source that the governor's relying upon in the future. And so, because we've now seen that when you give absolute power to somebody, they do what any baby would do with a rattle. They abuse that power. And it is my hope that that there is a silver lining in all this mess and all this pain in this trial that we are going through, is that we as a nation wake up and understand that, wow, our founders understood, they got this, and they understood that power can corrupt, and that our freedoms that are so precious, if we don't vigilantly watch and be willing to stand up to protect them generation after generation, we will lose it. Now is our time. Now is our time. If you were wondering if you were ever born to stand for something, and if you're a person of faith, think of Esther in the book of the Bible. For such a time as this, we perhaps are here to save freedom, save liberty for our children and our grandchildren. How we do it matters. We must do it respectfully. We must do it fearlessly, and we must be strong and courageous. but we must do it in a way that brings people into our camp and doesn't push them away. So that's my challenge to us. Equip yourselves. Let this be the first lesson, Constitution Law 101. I know we covered an awful lot of stuff here really fast. It's basically 28 weeks of lecture that I normally do in about 28 weeks of 3 hours a week, and we just did it in about 45 minutes. But feel free to go to our website, and I will give regular legal updates to this group. And our website is slgwitness.com.